A letter shows up from the hospital, weeks after your Illinois crash, claiming a piece of your future settlement. Before you panic, it's a lien, not a bill you owe today. And Illinois law puts a hard ceiling on it. All your medical providers combined can claim at most 40% of your total recovery, no matter how big the bills. Save the letter, don't call the hospital, and hand it to your lawyer. This is the rule that matters most, and the one people and a lot of online answers get wrong. Under Illinois' Healthcare Services Lien Act, every healthcare provider's lien, added together, can't exceed 40% of your gross settlement or verdict. Inside that 40, there are sublimits. Hospitals and ambulance services share a 20% slice, and doctors and other providers share another 20%. So even if your bills are enormous, the providers can't collectively swallow more than 40% of what you recover. And keep the nature of it straight. The line attaches to your settlement, not to you personally. It comes out of the recovery when it's paid, not out of your pocket beforehand. If there's no recovery, there's nothing for it to reach. There's even a bonus rule in your favor. When the medical lines hit that 40%, your attorney's fee is capped at 30%, even if the fee agreement said more. The law overrides the contract in your favor. Here's what a lot of people never learn. The hospital only has a valid lien if it followed the rules. It has to send a written notice, name you, the injury date, and every party who might be liable, including the at-fault driver and the insurers, and serve it by certified mail or in person. Miss a step and the lien can be unenforceable. And if the settlement was already paid out in good faith before the hospital served its lien, the lien can't be enforced at all. A late letter is often a dead letter. A valid lien is still rarely the final number. Hospital list prices run 3 to 5 times what insurers actually accept. And if the hospital is in network with your health plan, it may be bound to the discounted rate as payment in full, which can shrink or erase the lien. Many hospitals will simply take a quarter to 40% of the billed amount to close the file. One caution though. Unlike some states, Illinois does not make the hospital share in your attorney fees, so don't count on that particular discount. So, an Illinois hospital lien is a claim on your settlement capped at 40% of the whole recovery for all providers combined. It's not a bill you owe up front. Strict notice rules void a lot of liens, and even valid ones are usually negotiable well below the billed amount. Don't pay it blind. Everything I mentioned is linked below, including the full written guide with sources. This is new lore for Kaufman Townsley Injury Lawyers.